Good morning, this is your Kelso Report for Thursday, January 26th. I'm your host, Clark Kelso. We begin with a case involving professional responsibility issues. The joint defense or common interest privilege, which is an extension of the attorney-client privilege, recognizes that persons who share a common interest in litigation should be able to communicate with their respective attorneys and with each other to more effectively prosecute or defend their claims within the protections afforded by the attorney-client privilege. In United States v. Gonzalez, the Ninth Circuit faced the question of whether the privilege applies when the common interests between two defendants who had been charged with the same crime ultimately diverge into separate interests, and whether a subsequent habeas petition by one of the defendants alleging ineffective assistance of counsel waives the privilege. Factually, a husband and wife were charged with fraud involving an insurance scam with the wife's car. Shortly after learning that the car needed several $1,000s of repairs not covered by warranty, and only 10 days after the wife took out an insurance policy on the vehicle, the car was found burned in a field with a gas can in the back seat. Continuing the amateurish efforts, both spouses separately confessed to the fraud, but the wife claimed she had no knowledge that fire would be used to destroy the car. The husband initially said he burned the car, but that his wife knew nothing about it. Just before trial, the husband changed his story dramatically, asserting that he had previously lied to protect his wife, and that he had nothing whatsoever to do with the fraud. He was still convicted on the fraud counts, but acquitted on the use of fire count. The wife was convicted on all counts, and because she was convicted on the fire count, she received a mandatory 10-year sentence, while the husband was sentenced to only 8 years. The wife filed a habeas petition claiming ineffective assistance of counsel for the failure to call her husband as an exculpatory witness, and she secured subpoenas directed at the husband for disclosure of communications between counsel that the husband claimed were protected by the joint defense privilege. Although there was no written document reflecting a joint defense, the Ninth Circuit held that the evidence supported the existence of an implied common interest privilege. The court also held that since the common interest privilege is an extension of the attorney-client privilege, it could not be waived unilaterally by the wife when she filed her petition for habeas. So the only issue to be decided on remand is to determine exactly when the joint defense agreement terminated, since at some point the husband's interests clearly became antagonistic to the wife's, and whether the communications being sought occurred prior to that time, in which case they would be protected, or after that time, in which case they would be discoverable. Next, we have a case involving parole conditions. The constitutionality of applying federal sex registration requirements to juveniles was upheld by the Ninth Circuit in United States v. Juvenile Male. 3 juvenile defendants pleaded true to a charge of aggravated sexual abuse with children. The court imposed conditions of probation or supervision requiring registration under the Federal Sex Offender Registration and Notification Act. The defendants argued that the registration requirement contravenes the confidentiality provision of the Federal Juvenile Delinquency Act, and that, in any event, the requirement was unconstitutional. The Ninth Circuit rejected both arguments, first holding that Congress, in enacting the Sex Registration Act, intentionally carved out a class of juveniles from the protections of the Juvenile Delinquency Act's confidentiality provisions. And second, concluding that the Sex Registration Act was plainly constitutional under well-established precedents. Next, we turn to cases by the California Courts of Appeal. The first involves the area of administrative law and limitations on review. State law in California requires that a petition for administrative mandamus under Section 1094.5 of the Code of Civil Procedure must be filed within 90 days after, quote, the date the order is noticed, close quote. In the context of decisions by the Department of Motor Vehicles to administratively revoke a driver's license, the giving of notice is complete, quote, upon the expiration of 4 days after deposit of the notice in the mail, close quote. Well, putting these two requirements together, a petition for administrative mandamus must be filed within 94 days after mailing of the notice of final administrative action revoking a license. Unfortunately for the driver, he filed his petition on the 95th day, and it was therefore dismissed as untimely. A decision affirmed on appeal by the 2nd District in Vitquevez versus Valverde. You really have to count days carefully on the calendar. And speaking of short limitations periods, Section 65009 of the Planning and Zoning Law establishes an equally short statute of limitations, only 90 days, applicable to actions challenging several types of local planning and zoning decisions. In General Development versus City of Santa Maria, a developer requested a zoning change, and the City Council denied the application. For some reason, the developer did not serve its writ petition by notice and acknowledgement until 97 days after the decision. The developer argued that the 90-day period did not apply to a decision to deny a zoning change, as opposed to a decision to approve a zoning change. But the 2nd District, of course, slapped that argument away and affirmed the Superior Court's decision, granting the city's demur without leave to amend. Definitely a bad day for the developer's legal counsel. Don't make that mistake yourself. Next, in the area of civil procedure and settlements, Section 372 of the Code of Civil Procedure requires that a court review and approve a settlement reached in favor of a minor. In Pearson v. Superior Court, the 2nd District had a situation where the parties had settled a personal injury action in favor of the minor plaintiff and had filed a petition for approval of the settlement under Section 372. Unfortunately, the minor died about 3 weeks before the Superior Court ruled on the petition. The issue was whether the minor's death made the settlement unenforceable, an issue that was important because the settlement included a substantial recovery for pain and suffering, and those damages would be unavailable in the context of a wrongful death action. The guardian ad litem argued that under Section 372, only the minor could repudiate a settlement prior to court approval. But the trial court rejected this argument and entered an order denying the motion to enforce the settlement. The guardian then sought a writ of mandate, which the 2nd District granted, holding that a settlement agreement in favor of a minor, which has been submitted to a court for approval, is voidable only at the election of the minor or his guardian. Nothing in Section 372 suggests that its protections were for the benefit of a settling defendant or its insurance carrier. Its sole purpose is to protect the minor's interests. The 2nd District directed the Superior Court to enforce the settlement. Finally, a state law case involving bankruptcy. Now, as I noted in yesterday's Kelso Report, one of the models for resolving bankruptcies occasioned by a company's litigation liabilities resulting from asbestos has been to concentrate the company's assets in a trust fund and then channel all asbestos litigation to that fund. These plans are generally intended to bar all known and unknown claims against the company so that the trust fund becomes the sole basis for recovery. But this can raise an interesting due process issue when a previously unknown claimant who was unaware of the bankruptcy plan tries to sue the company for damages. The question is whether that claimant should be barred from suing because of the bankruptcy court's approval of the reorganization plan. That issue was before the 2nd District in Flores versus Kmart, where the plaintiff filed a wrongful death action and the defendant interposed a demur based on a prior bankruptcy plan. Emphasizing the extremely narrow legal question presented by a demur procedurally, and the limited record of the bankruptcy proceedings which were provided by the defendant, The Second District held that the defendant had failed to demonstrate at the demurrer stage that the approval of the reorganization plan actually barred all of the plaintiff's claims. The court's primary concern was the possibility that the plaintiff was never given any notice of the reorganization plan and may not have had any opportunity to object to that plan. Now, the court's decision, I think, may attract the attention of the California Supreme Court because it does seem to suggest that the asbestos-related bankruptcy settlements are not quite as final as everyone may have assumed. Clearly, the Court of Appeal was aware of that risk, which is why it did emphasize strongly that this was the ruling they would issue in the case of a demurrer, and obviously if they had a little more information, the result might come out differently. So it may well be that the parties will simply wait for the motion for summary judgment that undoubtedly is going to follow and see what the court does with the case at that point. And that's it for today's Kelso Report. Have a great day in the law.